So, back again. Welcome everyone. My name is Claire Fritz and I am representing the European IP Help Desk today, and it is my pleasure to welcome Orsola Lamberti from the Community Plant Variety Office here today with us. Hey Orsola, thank you. Wait, I will also switch on my camera. So, hey everyone. Hey Orsola, thank you very, very much for taking the time today and for being with us here again. I already followed, of course, your last sessions with us, which I enjoyed very much. And yeah, would you like to say a few words before I start or after I started?
After is fine, please go on.
Okay, then I'll just start immediately by stealing a couple of minutes to present the European IP Help Desk Initiative. Wait. So, as you all might know, we did migrate to a new website under the umbrella of the Europa server. The European IP Help Desk is a service initiative of the European Commission, and we exist already for more than 20 years. And we are trying to help European SMEs and beneficiaries of EU-funded research projects to manage their IP in the context of transnational business and EU research and innovation programs by, on the one hand, providing first-line IP support in form of a helpline, but also by providing IP training sessions like the one today, or by producing publications. Next to us, there exist also other international IP SME help desks that are focusing on other geographical areas like Latin America, China, Southeast Asia, or now as well India, and an African help desk is also in the pipeline, but not yet in place. And we are all now available, or you can find all information, all events, and everything we provide, all of us, on the very same hub. We call it the help desk, the IP help desk EC hub. You can see the new URL on the, well, here in yellow. I hope it's readable, or otherwise also on the upper right part of the slide. It's ec.europa.eu IP-helpdesk. And we regularly produce, as I said at the beginning, IP-related publications, all in English, like fact sheets, guides, infographics, but also audiovisual material like clips and videos, which are available on our YouTube channel. And they are also from time to time translated by our IP ambassadors, a cooperation scheme I will talk about in few seconds, a cooperation with the Enterprise Europe Network. And in our publications, you find, well, hopefully practical IP knowledge in form of also case studies, or, well, what I really like very much are infographics and the blog articles we produce regularly. Our helpline offers tailored and free advice on specific IP and IPR issues. Means our team of experts, here we have 3 experts that are waiting for your call from morning to evening or your email, and they are able to provide you with their IP support in English, Spanish, French, Italian, and Polish. But yeah, in the end, I think everything comes down to English. And we also recommend to send an email before. That helps you to think about the problem you would like to get support with through once in a written form, and then they are able to get back to you within 3 working days. And all information you're sharing is, of course, 100% confidential. But nevertheless, I need to underline that we do not offer legally binding advice, and you are also always invited to contact competent authorities, organizations, or private companies whenever you find it appropriate. And this is an overview of our upcoming events. As you know, we always offer training sessions from January to mid-end July, and then August is quite, let's say, inactive. We are of course working and the helpline is operating, but we are not offering any training events. And then we restart again in September. So the second curriculum starts then in September. So here we only have a few upcoming web sessions, like the one on communication, dissemination, exploitation with my colleagues Steffi and Jörg, or another one on the new copyright directive with my colleague Leslie, who is also responsible for the blog. And I just talked about this ambassador scheme, which is a cooperation between the European IP Helpdesk and the Enterprise Europe Network. For all of you who don't know what the network is, it's actually active in more than 60 countries, and it brings together more than 3,000 experts. And I think it's the largest, it's the largest network for small and medium-sized enterprises, or to support small and medium-sized enterprises with international ambitions. And here, members of the Enterprise Europe Network are also, depending on their individual profile, of course, focusing on intellectual property and the strategic business value of IP, and they join forces with us. They could then apply to become an IP ambassador, and they are providing free of charge IP business support, and you can find their contacts on our website as well. And now my last slide. I am of course obliged to tell you that this session is recorded. Means as well that all questions you are writing then later on in the Q&A part are going to be recorded and shared in form of the recording later with the community. Some housekeeping rules. You see that you are all muted. This is due to the fact that, then operating via the Q&A part means the questions part on the right side of your GoToWebinar control bar is easier than giving you all the right to switch on your microphone and to ask your questions. I will in the end collect all questions and we will go through them in a Word file. So Orsola has an overview of, and we can also go through them by a first come, first serve process, if you like. And yeah, that's it. I think I did share all the information I have for you. And now it's my pleasure to give the moderator's rights to Orsola so you can share your screen.
Okay, thank you, Claire. I'll just a minute. I'll try to be.
Take your time. I'm here.
Okay.
We see your screen, the presentation.
This is great. Okay, thank you for the opportunity, Claire. It's always a pleasure for the CPVO to collaborate with the help desk and to give us the opportunity to reach your community and exchange ideas. It's really interesting. So I'm very happy today to talk about IP rights in the agri-food sector. It's actually a very interesting sector where technology meets tradition, and for the aim of providing to our growing population more sustainable produced and more affordable, more nutritious crops, but at the same time also satisfy the needs of those consumers that are looking for a high quality product. So we will see how in this sector where we have plenty of business opportunities for new companies or also very old companies that work in a traditional way, it's possible to think about several IP rights and really reflect on your registration strategy. But before doing that, we need to know what the legislation offers to us and what's the function of the single IP rights on your products or services in the case of trademarks. So we will have a brief introduction, and then we will talk about the commonalities and differences and a separate assessment of these for IP rights today. I have to say that there may be other instruments and tools. There is also trade secrets and design on packaging. However, today we try to stay focused on the main IP rights used in this sector, and in particular on the science. We will also mention patents, which are also very important in this sector. However, we will focus on these trademarks, geographical indication, and of course, Plum Variety Denominations, because this is what we do at the CPVO. So science in our everyday life. As a final consumer, when you go to the supermarket, I'm sure that you're used to see how wide is the offer that you receive on the marketplace, and it's becoming more and more difficult to decide how to choose what product to pick or what service to pick according to our values as a consumer, according to our needs, and sometimes according to our budget. So science and the IP protection that comes with them helps consumers to address their purchase in the right way. You will see how science convey different values to consumers, and now can help us to make our choices. So today we will understand what's the difference between these two products. We see a can of Coca-Cola, so a trademark, a queso manchego, a very traditional, actually quite good Spanish cheese. And this is a bag of tulip bulbs. This is a picture that I took personally at Amsterdam airport, because it was really interesting to see how different signs were used. But in here we want to refer to the variety denomination that is very small, as parrot prints, and it indicates this very peculiar curly tulip. I bought it, it's really nice. So commonalities, except for patents, so that we will talk about patents later on in the end of the presentation. When we talk about trademarks, geographical indication, and plant variety denomination, we refer to signs that have the function mentioned before of helping us to identify the goods, and in the case of trademarks, also services on the marketplace. So this is directed to either final consumers or professional consumers. We will see the difference in a while. They provide information on the goods. Are they affordable goods? Are they quality goods? Do they bring value? Do they bring a hype with them? Are they Instagram products? And this is what they do. And they facilitate the purchase, right? Because it's easier for the consumer to see reflected their inner values in the values of the product. Within a competitive environment, once again, we have plenty of undertakings out there. It's very competitive. All of them tries to give a certain added value to their product, and it's essential that they manage to communicate their added value in the most efficient way. The differences are more about the information provided, the function of the IP right. You will see how this function differs. The right holders, sometimes we have an individual right, sometimes we have a collective right, sometimes we have an obligation to use. We will see in what terms. The scope of protection. Scope of protection is a very legal way to say what you can do, what you cannot do with your right, when you hold an IP right, what you can prevent the others to do without your authorization, where you can put condition, where you can ask for royalties, licenses, etc. The relevant public is different, and the applicable legislation. I shall say that I'm a lawyer, so I will also start from the legislation, because that's what contains the features of the right, the characteristics, and the rules that we have to follow. And this slide is just to tell you that these IP rights can meet each other sometimes. They can be used on the very same product in synergies if your IP registration strategy or IP strategy in general is correct. And sometimes there may be a clash among them. So their interface is not always Pacific, let's say, but we will actually explore this this topic in later on during this year in the second part of this webinar on the 28th of September. Today we will just define right by right and provide to you information on the main characteristics. However, it's important to know that they meet, they have an interface, and it's important to know how to deal with this interface, both when you work in the private sector as a consultant, as a company, you have to be aware of this relationship, and also when you work at an IP office, not a trademark office, etc. So we can start from trademarks and the legal framework. I will talk about European Union trademark. So this EUTMR is the regulation, the new regulation that is the legal basis for the protection of trademarks in the European Union. The protection of actually European Union trademarks. They are registered at the level of the European Union, so at UIPO in Alicante, and the registration of this right has a uniform effect in all the 27 member states. However, we can also have a national right. This is why we mention the national legislation too. But trademark, this is a definition that is applicable to both national trademark, US trademarks, trademarks in the European Union is a general definition, and trademarks are signs, as was said before, used to distinguish goods and services offered by one undertaking from those of the other undertakings in the marketplace. It's a very summarized definition, and we will see that explains the function of the trademark. Here we can see some of the brands, the trademarks that are out there. As you can see here, actually they identify goods, but as we saw before, they can also identify services. So the primary function is what we call the indication of commercial origin. Who is the producer of this good? I'll take the example of goods because it's easier to make a reference to our own experience when doing grocery shopping. But please remember, it's also for services. This is only valid for trademarks. Indication of commercial origin, it means that it allows the consumer to understand where that product comes from, not in a geographical sense, but in the sense of the company. Who is the producer of that, I guess, canned tuna? I don't know what I'm looking for at this, in this picture. It's very confusing. There is a lot of choice. And it allows companies to differentiate their products from those of their competitors on the market. So using different color, a different feel, maybe in the packaging, but also using the logo. Here before in eBay, the combination of color, as we can see in Google, the particular green of Starbucks and the logo is really very easy to identify for consumers. And we are talking about here very well-known brands, but this happens also with less known brands. So this is the primary function to make you understand who this product comes from. However, trademarks also have other functions, and this is really important to take into consideration when designing your brand before the registration of the trademark. Of course, it has a quality function. Let's say that the value of your product is it's high quality, like for Ferrari, as we saw before. It can be goodwill, so it's a way to say, I'm using this brand so you can trust me as a company. I have been working on this market for a long time. My cars are reliable. They're not only good cars, they're not only and they don't only create the hype on the product, but they also have this goodwill function and advertisement. So of course, the brand is not only on the product, labeling the product, but it's also using advertisement to remember to allow the consumer to have a link in its mind with that particular set of colors, that logo, that word. So what happens? The features of the right, we have to talk about the right. We cannot only talk about the colors and the field, but once the trademark is registered, so what I have to do is to file an application to an IP office. If I want protection in the 27 member states, I will choose UIPO, which is the European Union Intellectual Property Office. If I consider as a company that my business is only limited to France, for instance, I will apply at INPI, so the National Office for Protection, the National IP Office, and I will get my registration if everything goes well. If all the criteria are complied, I don't know, if your brand doesn't contain a swear word and everything goes well, you can have your registration. Once you have your registration, this paper from the day of application, you can have an exclusive right. You can prevent the others to use a word or that logo, to use the word without your authorization. This means that you can put conditions. You can ask for royalties or for the payment. You can conclude license agreements and make a profit out of your brand. It's potentially unlimited in time. It means that a trademark at the level of the European Union is renewed every 10 years, and until you pay for your renovation fee every year, it's okay. You can have your rights, and this also goes with the length of your business, no? Because your business continues, so you should be allowed to keep using your distinctive sign, and it's granted for a limited territory. So this is what we were saying before. If you apply before the French authority, you will have protection in France. You could have protection in the EU, in the US. If you're wondering about that, no, there is no, let's say, international trademark. There is no way to file one single application except for the Madrid system, but this does not have a unitary effect as in the European Union. So there is no office where you can file an application and have protection in all the countries of the world. This is also part of the strategy. You have to take in an element that you have to take into consideration when designing your IP protection strategy and licensing. We mentioned that before. So I think that I had a poll in this slide about geographical indication. I don't know if you can help me. Yes, okay. So before talking about geographical indication, I don't know if the poll will appear. Yeah, maybe you can read it.
Okay, yeah. Of course, wait. There it is.
I cannot read it. Maybe you can help it. You can help me.
Oh, of course. Which of the following is not a protected geographical indication? So now, please excuse my accent. Mozzarella di bufala campagna, Irish whiskey, queso manchego, ou paella alicantina. So which of these 4 products is not protected by a geographical indication?
Okay, yeah, I'm interested in knowing what do you know about geographical indications. Actually, they're used in our everyday life. They also help us with our grocery shopping, and some of them are more common than the other. Usually, I notice that we have the tendency to know the geographical indications from our country, or maybe this is about Italians. We really have a lot of them. So.
Can you see the results? Because I can, and I can read them out loud if you like. Or
Yes,
would
please.
you like to? Yeah, okay. Because I think almost everybody answered. So 8% say mozzarella di bufala, 28% of our audience say Irish whiskey, 13% say queso manchego, and 53% say paella alicantina.
We have an extremely smart audience because that was the right answer. So Paella Alicantina is not protected for a geographical indication. Actually, the Paella Valenciana is in the pipeline, is in the application step for getting its own geographical indication, but this is not done yet. And unfortunately, the Paella Valenciana, even if it's very tasty, doesn't have a right on it. So I'll start this geographical indication section from here. I told you I'm a lawyer, so I have to start from the legal framework, and this is the relevant legal framework. It's very important that you remember that we do not have one and only regulation on geographical indication, but it really depends on the sector. So we have a regulation on agricultural products and foodstuff, one on wines, one on spirits, and one on aromatized wines. So we have these 4 pieces of legislation. They are coordinated, so they share the same basic concept, but their object, their subject is not really the same. So GIs, this is how we call them, is the acronym. So GIs are signs used to identify a good as originating from a specific geographical region. So it usually, most of the time, has this geographical portion in it. Like in the mozzarella di bufala Campana. Campana is the region in Italy where this mozzarella comes from, except in the Paella Alicantina or Paella Valenciana, you have the Valenciana from Valencia. And it's important that this denomination contains this geographical portion. Why? Because we have specific geographical region where a given quality, reputation, or other feature of the good is essentially to be attributed to its geographical origin. So because this product comes from that region, it has a certain quality.
One
Yes.
comment, Ursula. I think you now, as the moderator, have to go back to your presentation, as we still see the poll, and I cannot change that.
Okay. Okay. Is that working? I'm on the presentation, but I'm on the presentation, Claire, but I cannot share my screen. Shall I? I have
Yeah,
this.
wait. Let's figure it out.
Show screen on. So.
Okay, worst case scenario is that I share my screen again, or we just switch one more time. Wait.
Yeah, you have to give me the rights probably. So.
No, you have the rights, but I'm taking them now from you to give them back to you. Perhaps this helps us. I think this could. Here, you have them again.
Okay. Is it working?
Yeah, now it's working. Yeah, now it's working again.
Okay, so
sorry for problems.
No worry, no worry. Okay, so you didn't see my amazing slide on the legal framework. So these are the numbers of the legislation, of the regulations at the level of the European Union, in case you're interested in reading them. May help you fall asleep. And this is the definition of geographical indication that we were discussing before. And now we were saying, indeed, that we use this geographical portion in the denomination of the geographical indication exactly because that region, in some cases, that country has a certain reputation. No? So, like it happened with the mozzarella. And this is an example, and to show you the 3 main elements of the geographical indication on the right, and we have the area, the product, and the link between them. So it's not sufficient that the geographical indication is used on a certain product that comes from the area, and we also need this link from between the two. No? So okay. Once again, the geographical indication of goods. What's the function of this sign on the product, on the foodstuff or wine or a spirit? Is that to indicate that a certain product comes from that area and to certify the quality and authenticity of the product. It also helps protect the biodiversity and the traditional knowledge of certain regions in Europe. This is a value that is very important, especially in some countries like France, Spain, and Italy, not only because they have agricultural production, but also because the system of GIs is more developed. No? This started from the idea of GIs actually started in France, and the countries that have the most are indeed the ones that we mentioned. So in these countries, it's really, but in all the European Union in general, it's really useful, it's really essential to preserve this traditional knowledge, also for the development of this agricultural region. It's an encouragement using this sign for this region to keep producing a certain traditional product in a certain traditional way. And also there is the social cohesion factor, which is also quite important when producers have to meet to harmonize their practice, when they have to meet to present an application to the Commission for this protection, or to make the public know, allow the public to know that that GI exists. Well, this of course helps the social relationships in these areas. So the feature of the right. First of all, we have to ask for a registration. It's essential to remember that in this case, there is not one single person that requests the registration, because the right is not individual, so it cannot be granted to one single person or one single company. Usually what happens is that the producer of a certain good, of a certain area, through a consortium, ask to the Commission for the registration of this GI. So in the case of Paella Valenciana, there was a consortium of producers that asked to the Commission and sent this application for registration. It is indeed in the European Union, the European Commission that grants this right. It takes a while, to be honest. And when I apply for registration, what I have to do is not only provide the Commission with the name of the geographical indication, but I also have to provide a set of rules, regulation, where I explain step by step how this product is produced. For instance, in the mozzarella, in what area the mozzarella is produced, what are the animals that I have to use, in this case, buffalo, and what are the breed, where the milk can come from. So the registration goes hand in hand with the approval of this regulation. And once the right is granted, every producer of their area that respects that regulation, which means that they produce a mozzarella exactly in their way, have the right to use the geographical indication on their product. There is no way to prevent anyone who respects the regulation to use the geographical indication. This regulation is called product specification, or in Italian disciplinare. It has different names. Usually they're quite, in all the languages are quite similar, but in this case it's not the case with the product specification. And it's really the definition of the scope of the right. I can prevent anyone who's not respecting the set of rules to use the geographical indication. And the GIs are also granted for a limited territory. However, you must know that the European Union has some agreements with third countries. This is, for example, they have an agreement with Mexico for their tequila. So we do recognize tequila coming from Mexico as geographical indication, and this is very important now for the economy of that country, of Mexico in particular, because the production of tequila takes a long time, and it's a name that is used more and more on the market for products that may not have the very same quality characteristics, and potentially is unlimited in time. This makes sense because geographical indication protect tradition, so protect something that has been made in a certain way for years, for centuries in some ways. So it is its function is really to encourage this traditional knowledge, the production in a certain traditional way for during time. And I actually have to tell you that when we talk about geographical indication, this is one denomination, one wording that encompasses three different rights. They have more or less the same scope. However, they have some differences. So today I'd like to explain to you the difference between protected denomination of origin, protected geographical indication, and traditional specialty guaranteed. So all of these three rights are called altogether GIs, geographical indication. And I have to thank the help desk for this table because it's actually Michele who made it. So I found it extremely clear, and sometimes it can be confusing because we call them in the same way and we switch between protected GIs and GIs. So I really keep this slide, it's very useful. So I will start from the traditional specialty, which usually, because it's a little bit different from the PDO and PGIs. Why? Because it's more about a traditional method of production. A traditional specialty may refer to a dish, for instance, is not necessary an agricultural product, is not necessary a wine, but it's something more complex, no? And what's interesting is that all the production step and the raw materials are not bound by any part of the territory. So we can say that this is the simplest way to get a geographical indication. Is more generic. However, it may be more complicated with PGIs and PDO. And the main difference between these two rights is really the connection with the territory. In PDO, protected denomination of origin, or appellation d'origine in French, for instance, the link with the territory is essential and is exclusive. So, for instance, if this right, the PDO, refers to a cheese, the milk to produce that cheese has to come from the very same area. You can see the difference in the product specification. If you compare the product specifications of the PDOs and PGIs, you can see that in the PDOs this is more strict, it's more complex to be able to label your product with this indication. And so I'm done with geographical indication, and I think that I have another poll about plant varieties. So I'm assuming that we are talking to beginners in the IP world, so you may not be aware of what a plant variety is. It's what we work for, is a niche in the IPR world, let's say, but I would like to ask the question anyways, so maybe Claire can help me.
Yes, the poll is already open, and the question is, which of the following is not a requirement to register your new plant variety? Excuse the typo in the question. It's supposed to say your new plant variety, of course. So either uniformity, novelty, or the inventive step. What is not a requirement? Please choose. 50% did answer already. I'd say we give it some more seconds.
Sure. I mean, the scenario is the one where you created a new plant, so a plant that is, for example, naturally resistant to pests, and you really want to protect it. What do you think is the requirement that is not required, let's say, to protect your new plant?
So 80% did reply. I'd say I close the poll now so we can all see the results. And here we have the results. So that means 24% of you said uniformity is not a requirement, 2% of you thought novelty is not a requirement, and the majority said with 73% the inventive step is not a requirement to register a plant variety.
Indeed. Before giving you the answer, can you confirm that you can see my screen, or shall we do the?
Yeah, no, wait, we can't see the screen yet, but
Okay.
I think I have to close, like really close the poll that nobody can see.
Yes. Yes. And in the meanwhile, I can give you the answer. And the answer is indeed inventive step. Inventive step, it's a concept that is proper to
It's weird that
patent.
it's probably my fault. I'm sorry that I'm not able to solve this problem differently. Yeah, we can see your slides now again
Yes,
without
cool.
me switching. Yeah, great.
Okay, so I'll just keep going with my presentation. So the answer to the poll is inventive step. Uniformity is one of the requirements for the registration of your new plant. Uniformity means that the plant, well, when you grow it and you observe it, your variety, all the individuals of your variety look more or less the same. There is some off types that are allowed in certain cases, but as a matter of fact, if the characteristic of your plant is that it's resistant to pests, when you grow 10 plants of your new variety, they all must have that feature. And the inventive step is a concept that we will see in patents. So just hang on with me. This was the last question, so don't worry. Plum variety rights. Before talking about the third sign that we use on the market, we have to clarify certain concept. So the sign is called Plum Variety Denomination. But first of all, we have to understand what is a plum variety and what is a protected plum variety. Now with the plum variety rights. I'll start again from the legal framework. Here, the most important regulation, our Bible here at the CPVO, the Community Plum Variety Office, is Regulation 2100 from 1994. Is what we call the basic regulation. However, we also have an international convention, and we have the national member states legislation, extra EU too. Okay. Okay, plum variety rights, a definition. First of all, I was telling you this. First of all, we have to start from the definition of a plum variety, and then we can talk about the protection of this plum variety. A plum variety is a precisely defined group of plants selected from a species and with a common set of characteristics. This is actually the simplified version of the definition that you can find in the law, which is quite complex and technical. However, it will become clear in a couple of slides. And we have the plant variety, so the plant, the way of defining a certain plant, and the plant variety right. So a sui generis form of intellectual property right that it's as object the plant variety. To understand what's a plant variety, it's essential to understand that the way we classify plants depends on what we call the phenotype. The phenotype is a very technical word to say that we classify them according on what they look like from the outside. So we do not really focus on the DNA too much, but on the external features of the plant. On the basis of these external features, we are able to classify plants in categories and subcategories, from the most general to the most specific. Of course, the most general is plants, the kingdom of plants. Plants are not animals, so they're not in the kingdom of animals. And then we can go more into the specifics until we get here in the genus and the species. You may be familiar with the concept of species. Through the genus and the species, we are able to identify a certain kind of plant. In our case, the apple is called the Malus domestica. You have Malus in the genus and domestica here is the species. However, why did I put a drawing of apple here, just the outline? Because as you can see, apples come in all shapes and colors, and we really need to identify we need a more specific way to identify certain apples. And so if I'm thinking of this green apple with a crispy flesh or certain growing condition, I also need the variety to know what's the variety. And I also need the variety denomination that in our case is Granny Smith. So this is the difference between the general Malus domestica and the specific Granny Smith. Granny Smith is a type of Malus domestica. And instead, since it's very difficult on the market to understand how to distinguish among all this variety, I cannot call my green apple with a crispy flesh all the time. I need a denomination. I'll just call it Granny Smith. So yeah, not all the varieties are protected plant varieties, like not all the machines are protected by a patent, not all the drugs are protected by a patent, not all the plant varieties are protected by a right. They may be a traditional variety, they may be protected by a geographical indication. I'm thinking about the lemon of Sorrento, where you do not really have innovation in there. You're not protecting innovation, but you're protecting tradition. But we will talk about this in our next webinar. These are just the basics. So the difference between a plant variety and protected plant variety is that we have an IP right on a protected variety. So this variety is innovative, as something different from the other varieties of common knowledge. And here are the registration requirements. So when am I able to register and protect the new plant, a new plant with a new characteristic? Well, when they have these 5 requirements: distinctness, uniformity, and stability. These are the technical requirements. You saw uniformity before. Distinctness is in a certain way a novelty, like in patent. It means that this new plant has at least one characteristic, one feature that is completely different from everything that we saw before. Stability means that cultivating it keeps showing the same characteristic generation after generation. Novelty means that it wasn't put on the market. And then we go to variety denomination. So we understood what's a plant variety, the most specific way I can describe a plant. We saw that we can protect a new plant variety. However, when I need to protect this new plant variety, I also need to give it a name, a variety denomination. However, we have to remember that the feature of the Plum Variety Denomination is that it's a generic designation of the protected plum variety. Why? This is really linked to the function of the denomination, which is simply to identify the product on the market. It's different from trademarks, where you can have also a goodwill function, a marketing function. You try to find an attractive name that the consumers can remember, that maybe is linked to your values, etc. For Plum Variety Denomination, this is not really the need, the aim that we have. The real objective is just to identify the product on the market. Why? Because usually on the market, which is professional marketer, what we can see in the brown variety are propagating material. So in the case of grape, you see these rare plantings, and it is not possible from this material to understand what are the growing conditions and what are the features of this plant variety. However, if to this propagating material I add a denomination that it can be early sweets, the person, the grower who is purchasing this material will know that the final product, the harvest material, will look like this. So this is the function, the main function of the variety denomination. And it's very important to remember that the variety denomination cannot mislead or cause confusion. And you have to remember, really remember, the difference between the variety denomination and the trademark, and think about it when you're designing your strategy as a breeder, your IP strategy as a breeder. So example on Granny Smith. So this is what we were saying before. To identify the plant material on the market, here you can see a lot of flowers and it looks very nice, but this is the final product. What you see on the professional market can be a brown bags of seeds. So it's really difficult to identify what's the result that those seeds will bring to me. And it is for professionals. Only in some residual cases, the plant variety denomination is seen by the final consumers. But for professionals it's usually more for professionals in the field of growing, which means there are the producers of apples, the producers of crops for our foodstuff. And this is something that I repeat over and over again. Plant variety denomination is not an IP right. It's the generic designation of the plant variety, right, of the protected plant variety, and it's a requirement for registration. So the breeder, the person who discovered or developed or bred the variety, has the obligation to give us a name to this variety so that we can identify it on the market, but does not have the right to this sign as such in the meaning of geographical indications and trademarks. On the other hand, quite the contrary, it has the obligation to use the plant variety denomination. The breeder, when it puts on the market the plant variety, is obliged to use that plant variety denomination, and this is applicable to all the subsequent steps of commercialization of that variety. This is because it's generic name. So we saw the example in this. Once again, once I see the plant variety denomination early sweet, I know what I can expect from this very, let's say, not mature plants. And you have to remember that where can I use my plant variety denomination? Only in propagating material, so only on this. We do not usually use it for the harvested material, usually, because it may happen. We do not absolutely use it for the products directly obtained from the plant variety. So imagine that we have a new variety of wheat on the seeds, of course, and the propagating material in the market for professionals. I am obliged to use the plant variety denomination. However, if after a certain numbers of steps in the production chain, I arrive to the final product, which is pasta, it is absolutely not necessary to label the pasta with the plant variety denomination. And this brings us to our last section, which is on patents. We talked about science until now. However, as we saw before, the agri-food sector is a sector where also innovation plays a very big role. It has a very high importance. So there are plenty of patents in the production chain, in the commercialization chain, etc. It's very important. Here we only make reference to the European patents, so not patents of the European Union. Up until now, it's very important to remember that in the European Union, we do not have patents with a unitary effect. So it is not possible, as it happens for geographical indication, trademarks, community designs, and community plant variety rights. It is not possible to file for registration at the European Union level and then have in effect a validity in all the 27 member states. Right now, the system of European patents is based on a convention. So what happens is that you can file an application and then you have a series of national rights that are managed in a centralized manner at the level of the EPO, the European Patent Office. However, this has a different effect. No? And this is because the unitary patent, which has been the dream of many lawyers in the field of IP, didn't come to reality yet. It's been, I think that the negotiation started in the 1960s and it's not done yet. So we hope that for the future years there will be some development in that case, because it will really help legal certainty at the level of the European Union. Anyways, a definition. This is a definition again that is applicable to all patents, European Union, national, US, more or less, and it is the following: a patent is a legal title granting its proprietor the right to prevent third parties from commercially using an invention without authorization. You may feel that this wording is familiar, and we saw that in the same way, but slightly different terms in trademarks and geographical indications, and it's also true for Plum Variety right. This is the essence of the exclusive rights that are granted when we have an IP. We have an IP right. In this case, the object of the protection is the invention. So let's say here the very complex machine that has a certain result and makes our life easier for a certain process. So the term of protection in this case is limited, it's 20 years from the date of filing. And there is a possibility for drugs only to have 5 years additional protection. This is due to the fact that marketing authorization in the case of drugs takes many years, so it's a way to compensate these companies. They make huge investments in their research and development programs before getting to the final result, the final protectable result, and before putting it on the market. And these are the requirements. According to the Patent Convention, European patents shall be granted in any field of technology. This includes agriculture, this includes food production and innovation in this sector. This is why I really wanted to talk about patents too in today's webinar. Provided that I have these three requirements. You can see we saw before with Plum varieties, we have 5 requirements. Here the requirements are 3, and you can see the inventive step that we saw before in the polls. That is not a requirement for Plum varieties, but for patents. The inventive step means that there is a certain degree of progress when compared to the common knowledge before. It's something the invention, of course, should not be part of that common knowledge, and shall be applicable, shall have an industrial application. There are some things that cannot be protected by a patent. This is very important to know, and it also gives me the opportunity to remind you again that we will talk about this clash with Plum varieties later, and you will see. So first of all, you cannot protect with a patent, so you cannot get a monopoly on a discovery, scientific theories and mathematical methods. You cannot have protection in relation to aesthetic creation. Why? In this case, it's just to avoid a double protection, because aesthetic creation can be, in the case of a work of art, protected by copyright, and when it's about the external appearance of a certain product, it's protected by designs, right? So it's not you should not use the patents in this to protect your creation schemes, rules, methods, and presentation of information. And finally, you cannot obtain a patent on plants or animals varieties, or essentially biological processes for the production of plants or animals. Why we have this complex wording? Because Article 53 of the EPC Convention actually was written a very long time ago, when the difference between a plant that could be protected with the Plum Variety rights and a plant that couldn't be protected with a patent was quite clear. At that time, we would talk about a transgenic plant material, so a plant material that received a section of DNA from a different organism, usually bacteria. However, This has technology has changed a lot, and the methods of creation of new plants or new plant varieties changed. And so this initial distinction, did you create the plant with a technical process or with the biological process, which used to be crossing and selection, is not really applicable anymore, because you have a lot of technology and methods in between. But for your basic course, you can consider that plants and animals should not be subject to patents. And these are just some examples of what you can do with technology in the agri-food sector. We have here a method for processing organic residues into fertilizer. This is very useful. And of course, a series of appliances and machines that make the production chain shorter, that make the production chain more efficient, and then may generate higher quality products and more affordable products for consumers. And thank you for your attention, your patience, for having replied to the polls. These are our contacts. You will receive the presentation, it's my understanding, so you will have them with you. And I'm done with my presentation. Thank you.
Thank you very much, Ursula. This was really a great presentation. I enjoyed it. And even for me, I'm listening also to kind of these topics, as you can imagine, very often. So I really, really like this version, and the way you are also including the interactive part with the polls. So more polls. I'm getting better, I promise. But I really like this part in the presentations. I don't see any questions yet. I did promise that we would share them via a Word file, but I think you made it very clear, and no questions did arise in the meantime. Or now is the time, in case you guys have questions, please use the questions part in the control bar, please.
In any case, if there are questions later, Claire, you may also share my email address. We are always happy to receive questions, because in the slides we have the functional mailbox of the communication sector that usually dispatches a little bit our communications. However, I don't mind receiving directly emails. It would be a pleasure to reply to you if you have any question. And maybe we can also remind about the second part of the webinar that will take place later in the year.
Yeah, of course, of course. So the second part for the webinar is planned for end of September, if I'm not mistaken. Of course,
Yeah.
I haven't opened the concept, but I think it's the 28th of September is the second part of the Agri-food webinar, and I'm already looking forward to it. And we also have some other webinars coming up with the CPVO and Geopora, but more about that. Well, I can give you the dates already if you like, but that's it, and the titles. And even also a question came in the meantime. Give me a second. I have to wait unprofessionally. I didn't open the concept in the meantime.
Maybe I can say something about the second part of this webinar that will explore the interface among especially the signs that we saw today. Yeah, we said that we gave some example of the IP rights that are used in the agri-food sector, and we will see how patents encounter plant varieties, how plant variety denominations encounter trademarks, how geographical indication encounters trademarks, what happens when the, one is registered before the other. So if you're interested in that, you can, I'm sure that you can subscribe the newsletter of the help desk, where you will be informed of the upcoming webinars. This webinar will take place on the 28th of September at the same time as 10:30, 12, more or less, depending on the length of the webinar and the questions. And we also have more. Another one will take place on the 8th of June we will explore together with our technical expert from the CPVO, the Community Plant Variety Office, Cécile Colognier. We will see what happens with what we call the new breeding techniques or new genomic techniques. Lately they changed the name of these techniques, and we mentioned before that the way of creating new plants really changed during the last 20 or 30 years, from the GMOs and the transgenic plants that we saw 30 years ago. A lot happened, so a lot changed in the way and the methods of creation of plants. So how should we deal with this new methods, and how should we use intellectual property in relation to them? So I think it would be a very interesting webinar also for newbies like me, like lawyers, because we really have to make an extra effort to understand what's going on in the biotech world, you know. So it's and Cécile is a great speaker on that, because she really simplifies everything and then to make us understand. So that's the 8th of June at 10:30 on the help desk too.
Yeah, I did mention that, as this is also in the list of the upcoming sessions of the service presentation I gave before, and of course the registration is already open. So in order to follow the AIDA principle, interest, desire, and then action, I would say just I will include the link also again in the follow-up email this afternoon, when we are sharing then the recording of this session and the presentation of Orsola. And then you can immediately, if you like, sign up. Well, we hopefully see you there again. And now I have also the dates and for the second part of the year and the titles. So on the 16th of September, we have a cooperation with the Geopora and CPVO about research and development projects, so PVP and research and development projects. Orsola, please correct me if I'm saying anything wrong. And then we have, as I said, on the 28th of September, then the second part of today's session, also again with Orsola. And as you said, the title is IP Rights in Agri-Food Sector, Part 2, Conflicts and Synergies Among GIs, Trademarks, Patents, and PVD. So Plant Variety Denominations. And then we have, as it's really a full series we just set up, and we are also planning to perhaps put it together in a very nice one-pager. We have another webinar on the 21st of October, especially for growers, also given by Geopora, and a webinar on the 2nd of November on enforcement. I saw that you gave this one also yesterday, Orsola, right? The enforcement one.
Yes, but it had a different target public, because this webinar that we gave yesterday, maybe we can share the link in the follow-up email, was targeting enforcers, so police authorities and customs. It was more about tips and tricks, and we will see our webinar on the second part of the year will be more for private sectors or in the public sector, but not enforcers.
But perhaps you can just get some tiny useful information then from the one yesterday to know what the others know, you know. Can always be useful, perhaps, if you want to trick them. Well, not saying anything. And then on the 23rd of November is then the last one for this series, and it is on quality and audit at the CPVO. So QAS is the short title. And this is it. Well, for me, this is really very much. I'm very happy that we set up this cooperation, and we are planning on other topics as well. So that means you all will receive another last poll after this webinar. Means we are asking for your feedback. What did you like best? What were you perhaps missing? Are there topics you would like to know more about we didn't consider yet? This is a two-way street, so vice versa. In case you would like to share something with us, use this poll, and we are always eager to optimize, of course. So for example, one comment was that people were would like to have more visual contact, so we thought it might be nice to switch on the cameras. Of course, what you see is what we are. we cannot change that, but it's much nicer to have perhaps then also some faces to look at during such web sessions instead of only listening. Before, we consider it more as a little radio transmission. But yeah, this was, for example, one comment. So feel free to comment as much as you like. And that's it. I know wait, before we stop, we've been asking for questions and we received questions. Wait. So there is one question from Fernando. Wait, I will copy it. But I can read it already out loud. Is it possible to patent wine for a created variety, or protection of the grape is the only IP tool I may use? So he's asking if he could patent then the product and not
Okay.
the grape.
Well, I would use the term protect the product in general, because patent something is when you use a patent instead of geographical indication or a plant variety. One is actually very interesting. It's a very interesting example of when you use a plant variety denomination also on the product obtained by the plant variety. As you can see, as you saw in pasta, you will never see on a pasta box the name of the plant variety, but this happens on the wine. And on the wine is a great example of synergy among all these IP rights. On the label, you can see, besides the obligatory information of the labeling regulation, of course, you can see the brand, you may see a geographical indication, and you may see a plant variety denomination. However, it's very important to remember that usually when you see a geographical indication, this is not linked in principle with the protected plant variety. Why? Because usually when you have a plant variety, a geographical indication, you're protecting tradition. So a wine made from a grape of traditional knowledge, which is not protected. While with protected plant varieties, you're protecting innovation, so new plant varieties. What you may see is maybe the name of the wine, you may see a brand, and you may see a variety denomination, but it may not be a protected plant variety. It is useful to remind you that all the plant material shall have a plant variety denomination, not only when it's protected. So when I put any grape on the market, even if I don't have an IP right on it, even if it's a 300 years old grape variety, I need to register it on what we call the common catalog. And for this registration, we do need a plant variety denomination, because we need to identify on the market what's protected and what's not protected. I hope that replied to the question.
Yeah, Fernando, just in case, well, you have more questions, please type them in, because I don't see more questions coming up. Or as Orsola said, so either you can make use of our helpline team, or of course, Orsola and the team of the Community Plant Variety Office are happy to receive your questions as well. And we will share all the contact details you need then to get in touch with the different, people. And I'd say, yeah, we're even a bit early. Usually it's just 4 minutes early, or so I'd say thank you very much. Thank you, Orsola, for being with us today. Thank you for this great presentation. And thank you all for being here with us and participating in our web sessions. And we are looking forward to welcome you soon again.
Thank you. Have a nice day.
You too. Bye-bye.